Judge, can you hear me?
Yes, I can. Thank you. Mr. Gray, is that you connected by phone?
Yes, sir.
Okay, all right. We're on the record in Gray versus Gray, case number 2311522. We have the plaintiff, Ms. Gray, appearing by Zoom video with her counsel, Mr. Vernon. We have Mr. Gray by phone appearing on his own behalf. This is set for a status conference today. A couple of months ago, the court ordered parties to participate in mediation. It looks like that did occur in December. So today's hearing is to determine what hearings are necessary to go forward to get this matter closed up. Mr. Vernon, on behalf of plaintiff, can you tell me the status?
Yes, Your Honor. We were unable to reach a conclusion or any agreements at mediation. We're going to ask the court to set this for a trial. I believe a half day would be sufficient.
Okay. Mr. Vernon, how many witnesses are you anticipating?
Certainly my client, and probably two more. They would be short just simply to testify to the value of items.
And all right, thank you. Mr. Gray, were you able to hear that?
Yes.
Okay. Do you think a half a day would be enough time for you to present whatever evidence that you want to present?
Are you talking to me?
Yes.
I don't have no evidence to present.
Okay. All right. So
I'm not the one
court...
asking for this.
Okay. All right. You understand that at that hearing, the court's gonna be making decisions about how to divide up the property of the marriage.
Okay, so I guess I need to hire an attorney now, right?
That's up to you. I think it probably would be helpful to the extent that there are things that you want that Ms. Gray's not agreeing to give you, and there are things that she wants that you're not agreeing to give her. An attorney may help you be able to prepare to present your arguments and evidence in support of that to the court.
Well, can I ask for 30 days to retain an attorney? I just started my new job today.
Yeah,
Before
absolutely.
we go to trial. Okay.
Oh, yes.
Give me the right to be an attorney. Yep.
Okay. All right. So the court will set this for a half-day hearing. I'll set it at 60 to 90 days out so that Mr. Gray has an opportunity to get counsel and be prepared. I will ask, and I'll put this into an order so that it's part of the file. So when Mr. Gray does get an attorney, he can get, or he or she can get a copy of it. But the court's going to order that each side provide the court with short trial briefs 7 days prior to the hearing, just setting forth their proposed division of the assets and debts. So the court has an idea of what matters are in dispute and each side's view of how it should be divided. And I'll put that into a written order that'll be made a part of the file, and I'll also send that out to both sides. Mr. Vernon, anything else I can address for your side today?
No, Your Honor.
Mr. Gray, do you have any questions about how we're going to go forward?
No, sir.
Okay. All right. Thank you. The court will send out notice of the date and time of that hearing. And again, the order reflecting what we discussed today. All parties are free to disconnect at this time.
Thank you, Your Honor.
Thank you.
Yeah. All right, Mr. Legal, are you able to hear me okay?
Yes, Your Honor.
All right, and we've got Ms. Coke connecting here. Ms. Coke, are you there?
I'm here.
Okay, great. So we'll go on the record. This is Hollander versus Secretary of State. This is file number 2411773. If I could have both sides put your appearances on the record, please.
Your Honor, Kyle Legal on behalf of the petitioner Ian Bullender.
Sierra Coke on behalf of the people.
Thank you. The record should reflect both sides are appearing by Zoom for this hearing today. This is an appeal from a Secretary of State denial. Mr. Legal, I did receive your brief. I had a chance to review the brief as well as the transcript that was provided and all the other records that were provided with it, along with the Secretary of State's written decision in the matter. So I've reviewed all the documentation. Is there anything that you wanted to present today by way of oral argument?
Not a lot, Your Honor. I just point out again, our main argument is that, the hearing officer indicates that he needs to demonstrate he can maintain sobriety outside a period of oversight. I think the reliance that was put on that unpublished case is not accurate or appropriate. She applied a very broad principle that certainly the court, I don't believe, applied in that particular case. We don't know the set of facts in that case and why they upheld that particular decision. We don't know if that person was in jail for most of that time or what type of parole they were on. So I don't think it can then be extended out to saying that any period of time under a oversight should not be counted. And then additionally, the hearing officer didn't even address the fact that Mr. Bullender had only been on probation for 10 months at the time of the actual hearing. And he had 16 months of sobriety before he was even placed on probation. His incident happened in June of 2022. He did not drink after that incident. He didn't enter his plea until April of 23 and then wasn't placed on probation until October of 23. So he had a long period of sobriety of 16 months that wasn't really accounted for, I don't believe, in the decision either. So it's our feeling that she misapplied anything in the unpublished case, ignored his 16 months of sobriety when he wasn't on any oversight, and that he clearly had established that at the time of that hearing, he had 26 months of sobriety. The hearing order does not do anything to discredit any of his letters, his evaluation, or counteract or suggest that his sobriety date isn't accurate. It basically accepts all the evidence that he presented, but then goes on to say that he must have this period of sobriety after he's off probation. And again, I simply feel that that is not the standard, and that he did have a significant period of sobriety and met all the requirements that need to be met by clear and convincing evidence to, at a minimum, at least get a restricted license. So we'd ask that the court either give full driving privileges or, in the alternative, grant a restricted license, or even consider a remand back to the hearing officer to indicate that the hearing officer's conclusion that there must be a period without oversight is not accurate, and have the matter reheard. Thank you.
All right, thank you. Ms. Coe?
The court has all the transcripts. I don't have anything additional to add, and I would defer to the court in terms of what the court feels is appropriate based on the transcript. Thank you.
All right. Okay, so the standard that the court has to follow, the court does not conduct a de novo review. In other words, the court is not in a position to substitute its judgment for that of the hearing officer in this case. The court's review is limited to the record that was presented to the the administrative law judge. And the court is to look at the judge's determination as to whether it's based on competent material, substantial evidence on the whole record. I think that's kind of the basis for Mr. Bullender's objection here or request for review. and also that the decision is supported by law. So I think there's also that element of the case law that was argued and cited here, whether or not the judge's decision, to the extent that's based on Mr. Hollander still being under court supervision, whether that's supported by law or not. So that's kind of the standard that the court's looking at. And in terms of the factual determination, it's more of an abuse of discretion standard, which recognizes that there could be more than one reasonable or principled outcome. And as long as the ALJ's decision is within the range of those outcomes, then it should not be disturbed. So that's the standard that the court's looking at. I reviewed very carefully, again, the transcript, the testimony that was presented, the written opinion by the ALJ or hearing officer, as well as all the supporting documentation, including the letters of reference that were submitted on behalf of Mr. Hollander. Really went through all the same evidence that the hearing officer went through. In addition to that, the court takes judicial knowledge of Mr. Hollander's underlying case. Generally, I was the judge that presided over his operating while intoxicated case and has been presiding over his supervision while on probation. So I'm well versed in the facts and evidence here. What I gleaned from the hearing officer's decision is, as Mr. Legal indicated, that Mr. Hollander hasn't demonstrated a sufficient period of sobriety outside of court supervision. And number one, I would note, and correct me if I'm wrong, Mr. Legal, but I believe Mr. Hollander, even pre-sentence and pre-plea, was still subject to bond conditions in this court, which would have required him to not consume alcohol. So while it's true he's been on probation for a shorter period of time than has elapsed since this incident occurred that led to his charges, he has been under some level of court supervision throughout that, at least since the charges were issued. And I don't have those exact dates, but I would assume that it would be a substantial portion of the time that his case was actually pending. So he really has been supervised to one extent or another by the court for the majority of the time that's elapsed since his charge. That's neither here or there. I think that's important to note for the record that he has been under supervision for most of that time. I think from a legal standpoint, counsel's correct that I don't think if the hearing officer said, I'm automatically not going to restore the license simply because Mr. Hollander has been under supervision and hasn't remained sober outside of that, I think there may be a legal argument to be made there. That's not what I got from the hearing officer's decision. What I got from the hearing officer's decision was that was a factor that she considered, and a factor that she relied on. I don't think she applied it as an across the board legal standard that would automatically disqualify him. I think she thought that was a factor, and I think there's nothing wrong legally for the hearing officer to have looked at that as a determining factor. I also think looking at Mr. Hollander's prior history, and I think the hearing officer did rely on this as well, my reading of it. He did have some significant periods of abstinence and a significant period before the latest relapse. And my reading of the hearing officer's determination is that, that's a concern when you have a substantial period of abstinence and then you relapse again. That tends to indicate that if Mr. Hollander has an alcohol problem, that it may not be likely to remain under control. If he could be abstinent but then relapse, that indicates that it's not under control because of the relapse itself. So looking at the opinion as a whole, reviewing it under the standard as I indicated earlier, and for the reasons that I've stated, I cannot find, even though I might come to a different decision if it was in front of me on a de novo review, I can't find that the hearing officer's decision was outside the range of principled outcomes. I can't find that it's not based on evidence or find that it is contrary to law. So the court's in a position where, again, I can't substitute my judgment. And I find that the hearing officer's opinion should not be disturbed under the legal standard in which I'm reviewing it. So for those reasons, the court is going to deny the appeal. And Mr. Legal, I would just request that you prepare an order indicating for the reasons stated for the record and submit that either with the stipulation from Ms. Koch as a form or under the second rule.
Will do, Your Honor.
All right, thank you. That's all for this hearing today. All parties on this case are free to disconnect at this time.
Thank you. Thank you.
on the record in Patrino versus Patrino, case number 2311369. If I could have counsel put your appearances on.
Thank you, Your Honor. Jason Thompson on behalf of plaintiff Katie Kaehr. We're both here in the courtroom today. Thank you.
Your Honor, David Leonardson representing the defendant, sits to my left.
We're here today, Mr. Thompson, you filed a show cause. Tell me where you're at.
I did, Your Honor. I've heard from Mr. Leonardson since the show cause. My understanding is his client would like to select a different realtor. You know, I think if we weren't in a sort of post-judgment, post-order standpoint, that might be a reasonable negotiating position, but I think it's past the time of negotiating. My client doesn't want to negotiate. She wants this listing agreement signed that the court ordered Mr. Patrino to sign. My client executed a new listing agreement yesterday. We're just asking to get that signed so we can get this house sold, which is what we've been trying to do the whole time. So Mr. Leonardson did contact my office. You know, I don't think he's doing anything inappropriate here. I just think his client hasn't signed, and I think she has to because she's ordered to. All right, Mr. Leonardson.
Yeah, there's been no intent of attempting to offend the court. What happens is that both parties have drawn a line in the sand, and neither counsel can seem to get the listing signed. Now, as to the argument, first, I'd like to handle this a bit. The argument for the listing. The property is jointly owned, but the contribution has been unequal. My client paid the down payment. She's paid the majority of the payments. Ms. Capernola has paid approximately $5,300 total towards the upkeep of the property. My client is in the property. She occupies the property and keeps the property up. She spent 3 to 4 times the amount of money to operate the property that Ms. Capernola has. For that reason alone, I believe that it would be pertinent that she has control of the listing. She has control of the property. And I have talked extensively to the listing agent or that agent. I'd asked him to attend this hearing, but he was called to a meeting. He's a realtor, and he had some out of area training to do, and he could not attend. What we would request the court to do is simply order Ms. Capernola to sign the listing agreement by Remax. Remax is the firm that my client has worked with extensively and is comfortable with that agent. I also have 25 years experience as an owner, broker, manager, agent, and I have some real estate experience, and I think that I could assist that agent in anything or any problems that they might have. I would put my client on the stand to answer some questions if the court feels that it's warranted. They both, originally, the offer was my client would be willing to pay $11,000 to cash Ms. Capernola out. And we were requesting a quick claim deed for that to happen. That linked around for several months, and there was a refusal to sign a quick claim deed. My client had had trouble getting a refinance through the finance company on the basis of an appraisal. She did get that after the judgment indicated she was supposed to do it by, I think, October 7th. She couldn't do it by that date, but by November, she had confirmed that she had acceptance of a refinance. That's really no longer on the table. The question is sale of the property. Has there been agreement that the property is listed at $165,000? The property was verbally appraised by a realtor in, I think, October of 2023 at $119,000. I don't feel the property will sell at $165,000, but the only way that this can be resolved this time is to get the home on the market, get an offer of purchase, and get some cooperation of the parties to sell the property and split the proceeds. We're willing to do that. We have been willing to do that for a period of time. But now it's not a matter of should the property be listed, but who's to list the property. And I believe that our argument warrants consideration by this court. It's much easier to work with the occupant of the property and we request that the property be listed at Remax.
So my question is, Mr. Thompson, who's your realtor?
It's the team realtor out of Team Real Estate Group, Margot Rumble out of Kaehr. It's qualified realtor. So I'm not saying Remax isn't qualified, but Ms. Crawford worked with this agent. This agent, invested her own time into it. Ms. Crawford comfortable with her. I do think there's some amount of, whether it's there's definitely a lack of trust between the parties. But yes, the listing contract I have with me that could be signed is from Team Real Estate Group. That's who my client, selected and presented to the court at the last hearing. The court ordered it. So that's where we're coming from.
Mr. Leonardson, other than your client just wanting to use the agent that she wants to use, is there some specific objection to their realtor?
She's not comfortable with it, with the other real estate associate. She's been contacted several times by that associate, and they haven't had a comfortable relationship or a professional, as far as I'm concerned. There seems to be underlying difficulty between the realtor associate and my client. I have not talked with them personally, but I've talked with the Remax gentleman several times, and I feel very comfortable with him and that he's a professional. And I still think that the control should be at my client's level on the basis of occupancy and a greater financial investment in the property.
Okay. All right. First of all, I think those are good reasons for Ms. Patrino to, all other things being equal, I think those would be good reasons to go with the realtor that you're suggesting. My concern here is, I presided over a number of hearings. My concern is I feel like Ms. Patrino is the one dragging her feet on this, and I think if she's the one directing the real estate agent, I feel like that's going to result in more delays here. This has already been delayed way longer than it's going to be. This needs to get done and wrapped up. I sense that there's a much more greater urgency on the part of Mr. Thompson and his client to take care of. And just my view of how things have gone, I feel like it's going to be wrapped up much quicker if they're the ones selecting the agent. Other than the reasons you stated, I'm not hearing any reason on why their real estate agent would be just as good listing property, getting sold, so forth. So the court is going to request to go with your agent. Do you have a listing agreement?
I have a listing agreement. I mean, the court already approved the listing agreement last hearing. I mean, we are at a stage of contempt, Your Honor. If we don't have a signed agreement, I understand the court to use the court's injunctive powers and injunctive relief. I also think my client should be entitled to attorney's fees for having to come here. And again, it's not that if this was at a pre-judgment mediation, it's not that that's an unreasonable negotiating position. It's that we already have an order that resolved this. And so we are here relitigating the November hearing.
I'm going to order that Ms. Patrino sign the listing agreement here today. To the extent Ms. Patrino that follow the order of the court, cooperate with this process. The next step will be contempt sanctions, which is fines, potential incarceration from you until you can comply. And certainly, I'm not going to award attorney fees today, but this is the last hearing following this. If we have any more hearings because you violated or failed to comply with the order, the court's going to impose Ms. Cavernaugh's attorney fees as well. So
Your Honor, I've been complying the whole time.
you haven't. I know you think you have, but for my chair here, you haven't. So you've been holding this up. And you've been asking, before the court ordered this, you wanted Ms. Kaehr to release her interest in the property without releasing her obligation on the debt. And that's an unreasonable position to take. And she was advised not to do that. And I think that's the right position to take. So you were holding everything up. You couldn't get financing. Okay, that's fine. The other option is to sell it. That's what we're doing. So,
I agree with the selling the house. The listing agreement has been ready ever since. The realtor and my attorney has been calling the other opposite attorney for this. I've been complying the whole time. So it looks like that it did not comply to you, but I did. I tried my best to save the house since I paid more than 50% of the house. I 100% upkeep of the house and 100% of the house bills of the house since the beginning I bought the house. I tried my best to save this house, but I agree with the selling and I've been complying whole time. That's all I can say, Your Honor.
did you sign up this thing?
I've been harassed with this realtor. That's the reason why I didn't go with this realtor, Your Honor, since August 7th. So I'm not safe and I'm not comfortable with this realtor. If you can give us a mutual realtor, that would be great.
Other than what you were just saying here today, I have no other reason to believe that this person would harass you. So
She did.
I'm ordering you to sign the listing agreement. If you decline to do that, I will hold you in contempt.
You have
I have a pen. Sorry.
Yes.
They're charged for the closing. I don't know. My client has indicated the $195 fee that that is part of this listing agreement. She finds it inappropriate.
I don't know.
It's just a fee they're charging for closing.
You know what? $190.
I believe he's indicating there's a provision on there that says there's a $195 fee at the closing. I believe for document preparation. I can show the court the listing agreement.
Is it a standard listing?
That's my understanding.
Remax did not ask that.
That would be split between parties, I would imagine.
You guys can work that out.
Yeah,
This isn't about negotiating at this point. This is about getting this listing agreement signed so we can get the home on the market and get it sold.
it would be taken out, proceeds, so it would be split between the parties. soon, contacting the realtor, that this simple courtesies would be taken.
Yeah.
The fact that she would contact her before coming home, showing the home.
That certainly
That's
sounds
all.
reasonable. Yes, that sounds very reasonable. I would agree to that.
Can you please with all that?
It's just standard. I've read it previously. It's the same document as presented by Mr. Wheeler. With the same blanks I filled in. I don't see that specifically there were any problems. It says that if you get an offer of $165,000, you require to sell the property. That's all it says this time. If you sell a property, there's a fee of $198 charged by this company. That needs to be determined. That's what DPP needs. That is to be determined. It's really part of the sale agreement. And so when possession would take, whether it would be at closing or they bring in some time to remove themselves. But
It's mentioned that once it's sold, it'll be inspection stay. Say.
that's just compensation. 7%.
Right, Mr. Leonardson, I need to move on with my docket. I've got 4 more hearings scheduled, so. Sure.
I'm saying,
Happy to go through it with Ms. Pedicino.
she signed this.
If it's signed now, we should probably make copies for everybody and then
Yeah,
obviously she can have it. to review it.
I have no problem with them bringing copies to me by mail.
You want to just confirm?
I can probably make them in one of the courthouse
Okay,
machines.
I'll wait for it.
Before we go off the record on this case, I'll need to review it.
Yes,
Make sure
sure.
that deficit.
Thanks, sir. Is this, Katie, is this supposed to be initialed every page now? There is a signature on the signature page. Your Honor,
Yes,
yes.
just need to initial.
Miss Cabrino had initialed every page. It's the way that was set up originally. But so Miss Patrino signed the signature page. She didn't initial each page of the document.
Why don't you guys, you can do that in the conference room or if there's a problem, I'll be here. We can go back to the record.
All right, and then I'll ask, I'll use one of the copiers here.
Well, and I'll wait until.
Yeah, the judge is indicating we should go back. There's a room here, it's just so she can initial every page. Okay, thank you.
Thank you.
Prentice, you can come right up to the podium there. Okay, I'll give you a chance to. Mr. Trush, are you appearing on Mr. Prentice's matter?
Yes, sir.
Or, okay. Okay, we'll go on the record in People versus James Prentice. This is case number 235153. The record should reflect Mr. Prentice is present here in the courtroom. Yeah, Ms. Chady on behalf of the people, as well as Mr. McFeld on behalf of pro probation. Mr. Trush is here for purposes of arraignment on behalf of Mr. Prentice. Mr. Prentice, you're here before the court for arraignment on some additional probation violations. Do you understand why you're before the court today? Have you been given a copy of those violations?
Yes.
Mr. Trush, have you had an opportunity to speak with Mr. Prentice prior to this hearing?
I have, Your Honor. I had an opportunity to go over the allegations with him, discuss what the difference between a technical and non-technical violation were, and specifically where these allegations fall and what his maximum jail exposure would be. At this time, we'd waive a formal reading of those allegations and stand mute to the charges. Ask the court to set it for a hearing. He has been screened and approved for counsel. Mr. Mertz will be appointed on that, and we would like to address.
All right, thank you. The court will enter a not guilty plea on behalf of Mr. Prentice as to the additional probation violations. Court will set this for hearing along with all the other violations that were set for hearing earlier today. I'll set all of them together for a hearing. Mr. Prentice had been released, I believe, on bond, $500 PR bond previously back in November. The court is going to readdress bond here today. Mr. McFelda or Ms. Chady, any position on what bond should be going forward pending this next hearing?
Judge, I would like to address bond. I do think I'm going to recommend Judge a $10,000 cash surety bond. Mr. Prentice is back using methamphetamine for the allegations. He also has some difficulty reporting to his supervising agent up in Charlevoix County. And I did want to point one more thing out, Judge, that when this case while his original case was pending, he was a failure to appear. They actually had a warrant out for him for approximately a year. So he does have a history of non-appearance. Thank you.
Mr. Trush.
Thank you, Your Honor. I would ask court to consider a 5,010% bond here. All three of the violations that we have before the court today are technical in nature, meaning that his relative jail exposure here is fairly low. Mr. Prentice reports to me that he appeared for court today, and that's also when he was arrested on the other allegations that were out there. So it's not as if he was trying to avoid anything or hide. He willingly appeared. So I would suggest to the court that does suggest that he's not a flight risk. It does suggest that a lower bond would be appropriate. Thank you.
All right, thank you. Mr. Prentice, was there anything you wanted to say?
Yeah, I want to first off start by saying I didn't realize that I was supposed to report to Patrick Stoner until about 2 days ago. And when I found out that I was supposed to report to him after I got out of in treatment, because I did 30 days. And when I got out, I thought I was supposed to come to the court date and we were going from there. I didn't know I had to report right to Patrick as soon as I got out. And that's I really didn't mean to, not see him, or else I wouldn't have been here today. Yeah, I'm just, I called this morning to let him know that I was going to be late. And she said that she was going to let you guys know, but I don't think the message ever got through. But no, I was most definitely here, ready to come before you in court. So.
All right. Aside from the issue of being late today, my biggest concern is that you tested positive with the here, which indicates to me that you're still using, despite the time that you spent in treatment. That's a concern for the court. You do have some prior issues with hearing. So I do think until we can get this set for a hearing and get it resolved, that the recommendation from Mr. McDowell is appropriate. So the court is going to set bond at $10,000 cash or surety, all standard terms and conditions, including the conditions of probation, and that the court will set this for a hearing within 14 days. I'm assuming, Mr. Trush, Is that something, I'm assuming you don't want to waive that, at least at this point?
Correct, and I certainly wouldn't feel comfortable knowing, again, Mr. Gurmurthy is going to be handling the matter. He should have the opportunity to formulate that plan.
Okay, so the court is required to have this hearing within 14 days, so it'll be set within 14 days, Mr. Prentice. We'll go forward at that time. Mr. McFall, anything further that we need to address on this case today?
No, Judge.
Mr. Truish?
Nothing further.
Okay, thank you. That's all for today.
Thank you.
Yes. Ma'am, can you tell me your name there at the Otsego County Jail, please? I cannot hear you. Hold on a second.
Your Honor, that appears to be Chelsea Brink.
Oh. Okay, I can you guys, I think I can hear you guys now. Yeah.
Okay, great.
All right, I'm sorry, Miss Brink, you look different today than you did yesterday, so I didn't.
I haven't done anything different except put deodorant on.
Your hair looks different to me for some reason. Okay.
Does it?
All right, Miss Brink, yeah, you're before the court here today for arraignment on charge of misdemeanor assault and battery. That charge alleges that you did make an assault or an assault and battery upon John Conradi. That is a misdemeanor that carries with it maximum possible penalty of up to 93 days and or a $500 fine. Do you understand why you're before the court today?
Yes, sir.
Okay. Mr. Brown, have you had an opportunity? First of all, I guess I need to go on the record. I'm sorry. This is Otsego County case 25-43389-SM-3 People versus Chelsea Brink. Mr. Brown is here for purposes of arraignment today, and we have Mr. Ford here from Otsego County Prosecutor's Office. Mr. Brown, have you had an opportunity to speak with Ms. Brink today?
Yes, I have, Your Honor. I did screen her as well. She would qualify, and that information has been sent to Mr. Gila's office for an appointment.
Okay. And then how does Ms. Brink want to plead to this charge today?
At this time, Your Honor, we will stand mute.
Okay, the court will enter not guilty plea on behalf of Ms. Brink. And in terms of bond pending the next hearing, Mr. Fortier, do the people take any position on that?
Sorry, I was muted there. Judge, we would ask for $1,000 cash surety or 10% bond. She does have some criminal history, albeit nothing too extensive. And then we also would ask for the court to order there to be no contact between Ms. Brink and the listed victim in the case, which is Sean Conradi. I'm not 100% certain as to the living situation at this point. We have his address as being the same as hers. So as part of that no contact order, we would ask that she just not be allowed to be at his residence or his place of employment. And I would leave it to the court if the court wanted to be specific with regards to an address, or just leave it generic to residents only.
Okay, thank you. Mr. Brown?
Your Honor, I am aware that the alleged victim was residing with Ms. Brink. It is her home. It is my understanding that this person was living there for approximately 2 months. Not quite sure if he is living there currently. She is well aware of the no contact order. I would ask the court not to put it as a specific address, rather the alleged victim residence. If he would vacate the premises, because this is Ms. Brink's home, and if she could bond out, I would ask that she be allowed to return home. If he is still residing there and she can post bond, I would also request a civil standby so that she could perhaps get some personal belongings. She does have a place to stay. She's a local resident here. As the court is aware, she was arraigned just yesterday or maybe a couple days ago on an FOC warrant. Bond was set in that matter. It is my understanding, regardless of the bond, she is not going to be able to post it. So I would ask court to take those things into consideration when setting a bond in this particular matter as well, and also consider the no contact order as far as residence versus a specific address.
Okay, all right. Yeah, I'm not gonna put a specific address. I have no idea what the legal status is of either of them with regard to, where they've been living. So I don't know, they've just been living together. If somebody, I'm not gonna speculate on the legal status of who's actually entitled to live at wherever they've been living from a legal standpoint. Given the nature of the charges, I do think no contact order is in place or should be in place. So the court is going to order that Ms. Brink not have any direct or indirect contact with Mr. Conradi or be within 50 feet of him, his residence or place of employment. The court will allow, to the extent that he's entitled to remain at the residence where he's at, will allow Ms. Brink to go there one time with law enforcement to remove any personal belongings she needs until this matter is resolved. And I will indicate that on the bond form. I will also set bond in the amount of $1,000, 10%. I think that's an adequate bond to ensure her appearance and to ensure that she will comply with the conditions of the bond. Ms. Brink, yes, what is it that you would like to say?
I just have a question as far as serving him with eviction papers. I'm gonna have to have contact with him in order to serve those papers and get him out of my house. So how should I go about that? I don't have any money in order to serve it via the law.
That is a question that you're going to want to ask Mr. Brown or whoever your court-appointed attorney is. They'll be able to answer that question for you. That would require me to give you legal advice, and I can't ethically give you advice about how to proceed with a eviction action.
I would
okay,
state,
I did. Go ahead.
Your Honor, I would state that I don't believe in no contact. If there is an eviction proceeding and the two have to appear together, I would assume the no contact order would affect a court proceeding.
Yeah, again, I'm not going to give an opinion on that. The bond says what it says, and she'll have to proceed based on the advice of counsel with regard to her any kind of eviction proceedings.
Thank you.
Okay, Ms. Brink, the next hearing that you'll have in this case is going to be on January 15th of 2025 at 9 a.m. So as soon as you're notified of who your court-appointed attorney is, you're going to want to make sure that you contact them so that you're ready to proceed on that date. And that's all I have for this case. So we're ready for whoever our next arraignment is. Thank you.
Thank you.
Shut the door and then you just put your back to the door there, sir.
All right, sir, can you tell me your name, please?
Lucas Allen Bell.
Mr. Bell, okay. Mr. Bell, you're before the court today for arraignment on a bench warrant that alleges that you failed to appear for a felony status conference back on March 14th of 2024. Do you understand why you're before the court today?
Yes, sir.
Okay. And again, this is People versus Lucas Bell, case number 2341788-FY-3. Mr. Bell is appearing today by video from Otsego County Jail. So, Mr. Brown, are you I'm assuming this is an active file in district court, so I'm presuming that an attorney has already been assigned to this. Is that correct? Are you the attorney of record?
That is correct, Your Honor. I am the attorney of record.
Okay. Have you had a chance to speak with Mr. Bell at all regarding this bench warrant?
I have, Your Honor, and when the court is prepared, I don't know if it wants to go through the colloquy of the arraignment first, but I would ask the court to perhaps have a very brief off-the-record discussion based upon my discussions with Mr. Bell.
All right. You know, this is a bench warrant. I'm not going to proceed with contempt sanctions today. I think what we really need to do is address bond going forward. It looks like he was initially released on a $5,000 PR bond. And, you know, in my view, being arrested and held for a period of time is a sufficient penalty at this point. Judge Hesselink may view it differently later on, but in terms of proceeding today, what I'd like to do is get a new bond set, just enter a not guilty plea on his behalf with regard to any contempt charge that may arise from his failure to appear, and then get set for a hearing so that we can proceed with this case.
Okay. Again, Your Honor, I understand the court's position. Just trying to advocate for my client based upon my conversation with him. I would like a very brief off-the-record discussion if that's possible.
Okay, yep, absolutely. So I'll put you both into a breakout room. So
I don't need the discussion with him, Your Honor. I need it actually with the court and Mr. Fortier.
Okay, hold on one second.
What time is it? I don't know, but it's probably a quarter after. Three. Want to get sentenced right now. Can. I'd rather run out to prison on Tuesday than we're working. What you gotta do to be trustee here?
All right, for some reason, sorry about the delay. For some reason, it would have made me wait 60 seconds before it would let me back into the courtroom. All right, be that as it may, so Mr. Bell, we've had a discussion off the record here. Your attorney, Mr. Brown, has indicated that you would like to enter into the plea agreement that was offered previously in this case. Is that correct?
Yes, sir.
Okay, so I'm going to go through that plea offer with you. The offer is for you to plead one count of use of methamphetamine. Maximum possible penalty for that charge is up to 1 year in jail. Do you understand that?
Yes, sir.
Okay. Also, based on your failure to appear and the fact that have absconded since March of last year, if you do enter a plea, the court is going to revoke your bond in order that you be held in jail until we can get a sentencing hearing
Yes, sir.
scheduled. Understand that?
Yes, sir.
Okay. With all of those things in mind, what is your plea to that charge today?
Guilty. Guilty.
Okay, I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. Do you understand all those rights?
Yes, sir.
And you understand that you would be giving up and waiving all of those rights by pleading guilty?
Yes, sir.
Also, because I'm the judge who's taking the plea today, you have the right to have your sentencing hearing scheduled in front of me. However, it would be my intention to have your sentencing scheduled in front of Judge Hesseling. Do you have any objection to having your sentencing hearing before a different judge than the one who took your plea?
No, sir.
All right. Has anybody threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we said here today in court?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty because you are actually guilty of this charge?
Yes, sir. I'm guilty. Yes, sir.
So, Mr. Fortier, I don't have the information. I'm conducting this without a file here in Crawford County. Can you give me the date of offense, or Mr. Brown?
Sure.
It appears to be on or about May 9th of 2023.
Okay. So the offense date, Mr. Bell, was back in May of 2023. Do you recall that?
Yes, sir.
And back in May of 2023, were you present in Otsego County?
Yes, sir.
At the time that you were present in Otsego County, had you used methamphetamine?
Yes, sir.
Did you have any legal right to use any amount of that substance at that time?
No, no legal right at all.
All right, thank you. Mr. Fortier, do the people find that the factual basis is sufficient?
Yes, Your Honor.
Mr. Brown?
Yes, Judge.
Mr. Fortier, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
I'm unaware of any, Your Honor.
Mr. Brown?
I am not aware, and I also believe the court has complied with statute court rule for taking pleas.
Thank you. Mr. Fortier, as to that issue?
The court's complied, Your Honor.
All right, thank you. Mr. Bell, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. The court will set this for a sentencing hearing. Ms. Payne, I don't know, do you have a date for that today that I can inform Mr. Bell of?
I believe that we could probably do it January 16th. That's the next day that Judge Hesseling will be on the bench. If the defense attorney and prosecutor believe that's enough time.
That's plenty of time, I think.
I have no objection.
Okay, so we'll set the sentencing hearing for January 16th. Mr. Bell, you be notified of the date and time of that in writing there at the jail. The court is going to order that Mr. Bell's bond be revoked and that he be held without bond pending the sentencing hearing on the 16th. Mr. Fortier, anything else that we need to address on this file today?
No, Your Honor.
Mr. Brown?
No, Your Honor. Thank you.
Okay. Thank you. That's all for this case today. And then I think our last one is Mr. Shephard or Miss Shephard. I'm not sure.
Yeah, Mr. Shepherd, we'll be right with you, sir.
Okay, thank you.
Put your back to the door. There you go.
All right, sir, is your name Casey Scott Shephard?
Yes, sir.
All right, we'll go on the record in People versus Casey Shephard, case number 2443179-FY-3. The record should reflect Mr. Shephard's appearing today by video from Otsego County Jail. If I could have counsel put your appearances on.
Good afternoon, Your Honor. Aaron Fortier on behalf of the people.
Larry Braun on behalf of Mr. Shephard.
Okay, Mr. Shephard, you're before the court here today because you failed to appear for a hearing back on November 21st of 2024. Do you understand why you're before the court today?
Yes, sir.
All right. And Mr. Brown, are you the attorney of record in this case?
I am not the attorney of record in this case. Previously, Mr. Shephard did not qualify for an attorney. He has most recently requested an attorney based upon my conversation with him. Since this allegation, his circumstances have significantly changed. He would qualify, and I have sent that information to Mr. Gila's office.
Okay. So again, Mr. Brown, my intention today would be to simply enter a not guilty plea on Mr. Shephard's behalf with regard to the contempt for the failure to appear and set that for hearing. The previous bond was $5,000 PR. That was revoked by the bench warrant. So we do need to set a new bond pending that hearing. Mr. Brown, or I'm sorry, Mr. Fortier, did the people take any position with regard to bond?
Judge, given that the original bond was the 5,000 PR, I would just ask for a new bond for 5,000 cash surety or 10%.
All right, thank you, Mr. Brown.
Your Honor, Mr. Shephard is 34 years old, lives in East Jordan. He has no prior criminal history, and this is his first alleged offense. I don't want to get into the facts too much of the case, but I would state that this is not a case of absconding for significant periods of time. We're talking about a couple of months here, and his failure to appear could very well have been because of some Zoom issues. These issues are usual, or these hearings are usually held multiple hearings at once, all scheduled for 1:30. And it is my understanding that perhaps Mr. Shephard was actually there via Zoom, however, may have gotten disconnected. It may have been an hour and a half, 2 hours before his case was even called. Given the technology and some of the issues that we've had before, especially when you have multiple people scheduled on the same time slot, I would ask court to give him the benefit of the doubt and reinstate his bond, especially given the lack of criminal history here.
All right, I mean, did Mr. Shephard turn himself in on this warrant or was he arrested?
I am unsure of that.
Okay.
I don't know if he knew he had a warrant.
All right, well, if, you know, even if there were technological problems, he certainly knew that he was supposed to be there for a hearing. And here it is 2 months later, and I'm assuming because you're not indicating that he turned himself in, that he most likely was arrested, which means he didn't voluntarily submit himself to the court. So I have concerns about his continued appearance, given the nature of the charge in this case, which is an assaultive offense, and given his prior failure to appear. I do think the bond suggested by the people is adequate and reasonable. So the court will set bond in the amount of $5,000, 10%, cash or surety. The court will include all the previous conditions of bond, which include no contact with the alleged victim in this case. The new bond will specify all those continued conditions, but the only thing that will change will be the amount. The court will set this for hearing. The next date will be on January 16th at 1:30 for a felony status conference. And Mr. Shephard, you will be provided with notice of the date and time of that hearing in writing, along with your appointed counsel. Mr. Fortier, anything further that we need to address for the record here today?
No, Your Honor.
Mr. Brown?
Nothing further, thank you.
Okay. All right, thank you. That concludes these hearings. All parties are free to disconnect at this time.
Thank you, sir.
I'll check it. Oh, yeah, good. Thank you.
They're gone.
Okay, great. That concludes our afternoon docket. The court will be in recess until